Hello everyone, this is Sivanda Tandulungus, and I'm going to be doing a presentation on the Insolvency and Bankruptcy Code, also known as the IBC. Now, the IBC code was enacted in 2016 to image the then existing laws related to insolvency and bankruptcy code. Before we venture into what really is IBC and its provisions, first of all, I would like us to look into what was the need for the IBC code, what does it entail. Prior to the IBC code, what were the laws that are dealing with the insolvency and bankruptcy? Now, there were laws like the Insolvency Act of 1986, the Sick Industrial Companies of 1985, the Companies Act 2013, among other laws that were used as recovery mechanisms prior to the enactment of the IBC Code 2016. These laws were contradictory to each other and they were also overlapping, and for this reason, there was a need to enact a uniform code that would consolidate the existing framework for the debt recovery by creating a single law for the insolvency and bankruptcy. So if we look, first of all, if we look into the Insolvency and Bankruptcy Code, the IBC, the name itself is categorized into three: insolvency, bankruptcy, and the code. So the insolvency part of the code simply entails that it deals with companies like corporates, firms. That's the insolvency part, and the bankruptcy part is for individuals. And then the code, it simply entails that the law, the legislation in itself, is a compilation of other laws, notification, regulations, etc., that with regards to insolvency and bankruptcy. What are the objectives, or what are rather the objectives of the IBC Code of 2016? The IBC Code of 2016 aims to resolve the insolvency of corporations, partnerships, individuals in a time-bound manner, and also to balance the interest of creditors and debtors. It also consolidates and amends the laws relating to reorganization and the insolvency resolution of corporate persons, partnership firms, and individuals. So basically, it could be said that the first and the foremost aim or objective of the IBC Code is resolution. It seeks to resolve claims dealing with insolvent companies in order to tackle the bad loan problems that were affecting the banking system by then. It also provides for a mechanism for distressed businesses to resolve insolvency in an orderly and a timely manner, which is in a bound manner. Now, we're going to move on to there are some processes that are provided under the IBC Code. These processes are also the same processes that should be followed in the application of insolvency and bankruptcy. The first one is the corporate insolvency resolution process, also known as the CIRP. This is provided under section 7 to 32A of the Insolvency Code 2016. The process at hand is initiated when the corporate debtor defaults a minimum threshold of rupees 1 crore. It also makes it mandatory for a resolution case to be complete within 330 days, failure to which the company would be liquidated. That is the CIRP. And then we also have the pre-packaged insolvency resolution process, which is also provided under the IBC Code section 54A to 54P. This is the mechanism to resolve the insolvency for corporate MSMEs, which is the micro, small, medium enterprises, through financial restructuring. Now, the aim here is to revive the business and prevent it from a complete failure, which also means that it simply provides for a quicker, cost-effective, and value-maximizing solution. And this was inserted after the introduction of the Insolvency and Bankruptcy Code Amendment Ordinance of 2021. Then we also have a third process, that is the fast track corporation insolvency resolution process, which is provided under section 55 to 58 of the code. This was initiated in order to provide an opportunity for the financial creditors to drive the insolvency resolution process for a corporate debtor outside of the judicial process while retaining some involvement of the adjudicating authority to improve the legal certainty of the final outcome. Now, it essentially provides for the insolvency resolution processes of debtor to be conducted within a period of 90 days, which could be extended by further 90 days instead of 180 days, extendable by further 45 days. And it also allows. Next is the liquidation process, which is compulsory and a voluntary liquidation process. After this, we're going to be looking at the 4 pillars of the IBC Code of 2016. So the code also has an institutional framework which contains 4 pillars, that is the regulator, the adjudicatory authority, the insolvency professionals, data utilities. Now we're going to look into those one by one, starting with the Insolvency Bankruptcy Board of a Republic of India, which is the regulator in this case. Now, this body deals with the education of the arena, implementation, and the operation of the board. It also has a restrictive and a superior power to deal with the insolvency and bankruptcy. So all matters associated with the Insolvency and Bankruptcy Code are handled by the court. It does not only control the profession, but also the processes that are involved in the same case. It is also important for implying the code that amends the laws relating to the conversion of insolvent powers, that is the Insolvency and Bankruptcy Board of the Republic of India. The second, we have an adjudicatory body, which is the National Company Law Appellate Tribunal, also known as the NCLT. So this functions as a single forum that undertakes the resolution of insolvent incorporate entities. As an adjudicatory authority, any appeal that is created under this NCLT can be quashed, or a stay order can be initiated against that order. It is the right forum where the appeals under the NCT can be created. So this is under the Appellate Tribunal. The Supreme Court, being the apex court of India, is entitled to hear appeals against the order of the NCLAT. In the case of a reorientation of the company is not possible, the NCLT might order for the cessation of the company entity. And then there is insolvency professionals, which is redirected under the IBC Code. These are directed with the work of overseeing varied aspects of insolvency resolution. They are an additional body also known as the Insolvent Professional Agencies, which is incorporated for the entitlement of regulating work for the insolvency professionals. Practitioners practicing individually are needed to be enrolled with the insolvency professional sector for controlling and developing the role of the insolvency professional. And for a person to be an insolvency professional, they have to be a member of the Insolvency Professional Agency. They have to be registered with the Insolvency and Bankruptcy Board of India. They are to be involved in the dissolution process of companies, LLPs, and they play an important role in the insolvency process. And in India, so far, there are about more than 800 insolvent professionals that are dealing with the same. And the last one is information utilities, which is tasked with the gathering, collecting, and passing of the information from the creditors to the corporate. This was envisaged with the information utilities under the Insolvency Code of 2016. Now, the information utilities are present to fulfill the loophole present in the country, which means that under Section 209 to 216 in the Charter of the Code, the governance, originating, and the core services of the information utilities is legislating. Only the Insolvency and Bankruptcy Board of India has the ability to license the IUs, which is the information utilities, and they can also exercise the power to control them, as well as the grouping of knowledge to provide such access to the information. And as of now in India, only the National E-Governance Services Limited is the operative information utility at present. Now, along with this, there are also some key provisions of the Insolvency Bankruptcy Code Amendment Ordinance of 2021, which is an amendment of the 2016 Code. The amendment allows the use of the pre-packaged insolvency resolution, as I already explained before, which is an alternative resolution mechanism for MSMEs. The threshold limit to trigger the pre-packaged insolvent resolution is between rupees 10 lakh to 1 crore, according to the Amendment Ordinance of 2021. In its Section 54A, it also allows the use of the pre-packaged insolvency resolution. Now, the P, which is also known as the PIR, it further allows the approval of the resolution plan from the National Company Law Tribunal. However, the submission of the resolution plan cannot happen directly to the NCLT. It requires an approval of the minimum of 66% of financial creditors that are unrelated to the corporate debtor before the submission of the resolution plan. And according to the ordinance, the threshold limit to trigger the PIR is between rupees 10 lakh to 1 crore, as I already explained before. And the NCLTs must also consider a pre-pack insolvent proceeding before allowing the corporate insolvency resolution process, which is simply a process of resolving a corporate insolvency according to the provisions of the IBC Code. We also have some landmark judgments that have been passed throughout the years in reference to the IBC Code by the Supreme Court. One of these most notable one is the Swiss Rebonds Private Limited and another versus the Union of India, where the validity of the IBC survived the test of its constitutionality. The Supreme Court upheld that the IBC in its entirety is constitutional, which also laid down the reasoning behind the differential treatment of financial creditors and the operational creditors, clarified the role of a resolution profession who acts as the facilitator to the resolution process, and stated that the IBC is not a mere recovery legislation for creditors, but it actually provides an opportunity for corporate debtor to be back on its feet. That was one of the cases where the constitutional validity of the IBC was upheld. And then we also have another case, which is the K. Sashida versus the Indian Overseas Bank, where the Supreme Court in this case curtailed the jurisdiction of the adjudicatory authority, which is the National Company Law Tribunal, by observing that the NCLT has no jurisdiction and authority to analyze or evaluate the commercial decision of the Committee of Creditors. So altogether, in conclusion, it can be said that the IBC is considered as an improvement in the two earlier laws that were regulating the recovery of loans, that is the Sikh Industrial Companies Act of 1985 and the recovery of debts due to bank and financial institutions of 1993. The IBC consolidated all these laws and accomplished a different achievements, which led to a speedy disposal of cases, as before enactment it took about 4 to 6 years for this disposal, but after the enactment the whole process got completed in around 316 to 330 days, and this resulted in a higher recovery of cases. Thank you.